What if I told you that the Supreme Court just made a move so shocking, so unprecedented, that it could completely rewrite the future of gun ownership in America? That's right, in an emergency decision that has already sent shockwaves through every corner of the nation, the Supreme Court has effectively moved to end all firearm permits as we know them. The ruling, described by some as the most radical shift in Second Amendment history, raises massive questions. Are we witnessing the ultimate expansion of gun rights, or the beginning of a dangerous era of unregulated weapons? In today's video, we're diving deep into this explosive decision that's dominating headlines and fueling outrage across both political lines. Critics say this could lead to absolute chaos: no more state-issued gun permits, no more background checks tied to local authorities, and possibly no way for law enforcement to track who carries a weapon. But defenders of the ruling are calling it a victory for freedom, the final restoration of the Second Amendment to its true constitutional meaning. What exactly happened behind closed doors that led to this emergency order? Who voted for it, and why was the decision pushed through so fast, with so little public debate? We're going to uncover what's really going on here, from the hidden motivations of certain justices, to the state reactions already flooding in from California, Texas, and New York, where lawmakers are scrambling to find ways around the ruling. We'll also explore how this decision could impact your everyday life, from traveling across state lines with a firearm, to buying, selling, or even carrying one in public. And yes, there are already reports that federal agencies are quietly meeting to discuss possible emergency responses. Some say this could even trigger new lawsuits, constitutional crises, and political battles unlike anything we've seen before. This isn't just another court ruling, this could be the turning point in the entire debate over guns in America. So make sure you stick around until the very end, because the last revelation I'll share will leave you absolutely stunned. Before we dive in, don't forget to hit that subscribe button, give this video a thumbs up, and drop a comment down below telling me what shocked you the most about this historic and controversial decision. Trust me, you're going to want to see how this all unfolds. 1. Dramatic hook and quick summary of what happened. What if everything you thought you knew about gun laws in America changed overnight? Picture this. The Supreme Court, in a sudden and extraordinary move, issues an emergency decision that shakes the foundation of firearm regulation across the entire country. That's exactly what's happening right now, and it's sending shockwaves through every level of government, from Washington, D.C. to the smallest local police departments. This isn't just another legal ruling buried in complicated language, this is a direct hit to the very structure of how Americans own, carry, and control firearms. For decades, gun permits have been the core mechanism that balanced individual rights with public safety, setting rules about who can carry, where they can carry, and under what conditions. But now, that entire framework is hanging by a thread. The Supreme Court's latest emergency decision appears to strip away much of the authority states once had to regulate firearm permits, throwing open the doors to what some are calling a constitutional carry nation. It's a radical turn that has divided experts, lawmakers, and citizens alike. Supporters hail it as a long-overdue victory for the Second Amendment, the ultimate return to the founders' vision of an armed and self-reliant populace. Meanwhile, critics are sounding alarms, warning that without structured permits and state oversight, the risk of untrained or prohibited individuals carrying guns in public could skyrocket. The situation feels chaotic because it is. Legal experts are scrambling to interpret the court's wording, governors are calling emergency meetings, and law enforcement agencies are waiting for guidance on how to enforce or not enforce existing gun rules. What makes this moment so powerful is that it's not just about law, it's about identity, freedom, and the limits of government power. The court's decision has forced Americans to ask themselves a difficult question. Is more freedom always safer, or is some regulation necessary to keep the peace? As this story unfolds, one thing is certain: this emergency ruling isn't just rewriting policy, it's rewriting history. 2. Legal foundation: how recent Supreme Court precedent opened the door. To understand why an emergency order could be so disruptive, you must go back to the doctrinal shift the court began enforcing after Bruin and continued to refine in later cases. Bruin required courts to evaluate modern gun restrictions by looking to historical tradition and analogs, a methodology that has already invalidated or narrowed several state-level permitting schemes and may-issue rules. Then, in cases like United States v. Rahimi, the court clarified limits and exceptions, upholding some federal prohibitions for specific dangerous groups while stressing historical analog analysis. But the aggregate effect is a court that prizes close judicial scrutiny defined by historical fit rather than by balancing tests. That shift makes many contemporary administrative and permitting mechanisms more legally fragile, If a state's permitting law cannot be plausibly mapped to a historical analog that the court finds relevant, it risks being struck down or curtailed, and on the emergency docket, those curtailments can happen overnight. As a result, the legal foundation for permits now sits on a doctrinal tightrope. One more emergency application could swing a major change. 3. What end-all firearm permits would mean practically scenarios and immediate impacts. If an emergency order or a controlling decision were to nullify the legal basis for state-issued permits nationwide, or to block enforcement of permitting laws in a set of major states, the consequences would cascade fast. State background check and permitting infrastructure could be rendered partially inoperative. Many shall issue and may issue permitting regimes would face immediate litigation or administrative paralysis. Law enforcement guidance about carrying across jurisdictions would become inconsistent. Gun dealers and private sellers would be unsure which state or local rules govern sales and transfers. Employers, schools, and private property owners would confront new ambiguities about allowing firearms on premises, and insurance, liability, and public safety planning would have to be rethought almost instantly. At the same time, states hostile to such a ruling would attempt emergency fixes, e.g., creating new statutory language framed to match historical analogs, passing temporary ordinances, or invoking state police powers to regulate conduct in novel ways, while other states might immediately relax permitting and enforcement. The net result: a fractured map of firearm rules that changes day to day, producing confusion, political fury, and an explosion of new lawsuits and emergency filings. This is not just theoretical. Political and prosecutorial responses at the state level are already changing in light of recent rulings and administrative signals. 4. 6 key flashpoints where the fight will be decided, and what to watch. First, watch the emergency docket. The court's increased use of emergency applications to resolve politically charged issues means split-second legal outcomes that bypass the usual months-long deliberative calendar. Second, look at state legislatures and attorneys general. The ones that move fastest will shape the practical aftermath by passing new laws or seeking stays. Third, monitor federal agency guidance and DOJ memos. Prosecutors and federal agencies could, and have, shifted enforcement priorities in response to high court signals, which alters how laws are applied on the ground. Fourth, expect a wave of coordinated legal strategies from major interest groups on both sides, NRA, gun safety organizations, state public defense coalitions, that will flood courts with challenges, amicus briefs, and emergency applications. Fifth, pay attention to how lower courts react. Many district and circuit judges will be asked to implement or block new policy in real time, and inconsistent circuit rulings could push additional issues straight back to the Supreme Court. Sixth, keep an eye on unionized or private sector policy responses. Employers, universities, and venue operators will have to rewrite safety and carry policies at the speed of news cycles. Each of these flashpoints is already showing signs of movement in 2024 to 2025 litigation and emergency filings, and together they form the battleground for whether permitting regimes survive in any coherent form. 5. Political and social fallout. Votes, courts, and street-level reality. A court-ordered or court-enabled collapse of permitting would immediately become a top-tier political issue. Lawmakers will use the moment to rally constituencies. Some will argue that ending permits restores a pure reading of the Constitution and protects citizens' self-defense rights. Others will say the decision unleashes risk, increases gun violence, and undermines public safety. Expect federal legislative proposals whether to codify permits, to create federal baseline rules, or to restrict the effects of any Supreme Court emergency order, even if passage is politically fraught. On the ground, first responders, police chiefs, and sheriffs will have to issue new guidance, and training and resource allocation will shift. The social consequences could be immediate increases in private purchases, market shifts in firearm sales, and changes to municipal ordinances as cities try to retain local control via zoning or venue rules. News coverage, protests, and grassroots campaigns will amplify the legal debates into everyday political pressure that could determine upcoming state and federal races. Recent reporting shows the court's emergency docket and certain prosecutorial policy shifts have already had measurable political and enforcement consequences. 6. What to expect next. Litigation strategies, practical advice, and the worst baseline, best outcomes. Litigation will explode. Expect dozens of emergency applications, coordinated state lawsuits to preserve permitting, and countersuits by parties seeking national uniformity. Practically, gun owners should document compliance with current law and follow official guidance from state police and licensing authorities. Sellers and retailers should seek legal counsel about transfers and record-keeping. Employers and property owners should update policies and insurance counsel. Worst outcome: a sustained nationwide vacuum in permitting that produces chaotic cross-state carriage and enforcement gaps until Congress or the court issues a definitive remedy. Baseline outcome: a fragmented map with some states preserving permits via new statutory language and others being forced to adapt to a more permissive regulatory environment, producing short-term confusion but gradual judicial clarification. Best, from the perspective of stability, targeted Supreme Court guidance that narrows the doctrinal questions and gives lower courts and legislatures a clearer template for preserving safety-oriented permitting measures that meet the court's historical analog test. Which of these happens will depend on the speed and content of both emergency orders and follow-up statutory fixes in state capitals and in Congress. Multiple recent emergency filings and court decisions indicate that all three scenarios are plausible, and that the near future will be legally and politically tumultuous. If this caught your attention, don't forget to like, subscribe, and comment what shocked you the most, because this story is only getting started.